Hi, and welcome back to Focal Point AFR Talk. Brian Fisher. Program is Focal Point. The network is AFR Talk, coming to you live from the Values Voter Summit in Washington, D.C. Heard some great speeches this morning. Michelle Bachmann, Senator Rand Paul gave a great speech on the importance of America coming back to God. Michelle Bachmann, a great speech on the danger threat of Islam. Paul Ryan, a great speech on a range of conservative issues. And I'm honored to have with us another guest here at the Values Voter Summit and a co-sponsor of this summit, Liberty Counsel. Matt Staver in studio with me. He is the founder and chairman of Liberty Counsel, the dean of Liberty Law School. Matt, welcome back to Focal Point with Brian Fisher.
Thank you. It's good to be with you, Brian.
Well, Matt, one of the things we've talked about before is ObamaCare, and of course this is still an issue that's percolated, given kind of fresh life by the Supreme Court decision this summer, which I haven't talked with you directly about this. I found that decision and Judge Roberts' reasoning, frankly, very difficult to believe. What was your take, just from kind of a constitutional and legal standpoint, just being as objective as you can? What did you think of the soundness of the argument that upheld Obamacare?
Well, it's completely unsound. I think I was, like many people, shocked because everyone was predicting that it was going to be struck down based upon the oral argument, how it went. And in fact, after the oral argument, the justices got together, as they do during any oral argument, and they voted. And at that time, it was a 5-4 decision to strike it down under both the Commerce Clause and the Taxing and Spending Clause. And so Chief Justice John Roberts began writing the opinion, but later on, he changed his mind, and he tried to get the other 4 justices to come with him, and they would not, and so he ultimately went with the dissenters on the Taxing and Spending Clause. It is completely inconsistent with the decision itself. It's completely inconsistent with the Constitution. For example, to say that the Anti-Injunction Act doesn't apply, but by the way it's a tax, is inconsistent. You can't have both of those conclusions. The Anti-Injunction Act applies to any tax, so that you cannot file suit against the tax before the tax is imposed. You have to first have the tax imposed, ask for a refund. You don't like the refund amount, and then you ultimately file suit claiming that it's unconstitutional or that you should have a different refund. But you cannot file suit on a tax before the tax is actually imposed. In this case, if it's a tax, the Anti-Injunction Act applies. And if it applies, you can't file suit until sometime after 2014 into 2015 when the tax is actually imposed on your tax returns. You protested in 2015, and then you file suit. The court would have no jurisdiction. So to say that it doesn't apply, but by the way it's a tax, is 2 contradictory, impossible conclusions.
Well, and I just think about it, Matt, from the standpoint where Judge Roberts said, look, you cannot constitutionally mandate that people purchase this product. You cannot do that. It exceeds the power of the Commerce Clause. But you can punish people that don't.
Yeah, makes no sense.
And call it a tax instead of a penalty. I mean, there's no logic to that.
There's no logic to it. Essentially, you can do exactly what the government wants to do on any situation. You just can't force them. But what you can do is if they don't do it, you can tax them. So you are coercing them through tax. It makes no sense. The statute itself did not call it a tax. It called it a penalty. There's multiple reasons inherently within the statute why it's not a tax. There's multiple reasons in the Constitution and in the precedent why it cannot be a tax. And in fact, if it's a tax, this gets more complicated. The question is whether it's a direct tax or whether it's a capitation tax, and that's prohibited by these various kinds of tax that are not equally apportioned like this are prohibited by the Constitution. Roberts has only a couple of pages to that issue, and that's a very complex issue, and he just blows it off.
Well, and I was particularly troubled, Matt. I'm talking here with Matt Staver, who is the founder and chairman of Liberty Counsel, dean of Liberty Law School. And I want to get to the legal action that you have taken, but I was really troubled by kind of his justification for bending over backwards to try to find some way to uphold this law. Like, he was saying that was his priority, his responsibility was to try to find some way to uphold this law rather than have his priority be to measure it against the Constitution.
Well, what he actually did is he wrote the statute and upheld his own version of the statute, frankly, and not only on the individual mandate, but, for example, on the Medicaid. The Medicaid under the statute had 2 different options. Either you completely withdraw from Medicaid as a state, or you add on the additional Obamacare imposition of Medicaid. There was no in between. There was no withdrawing and keeping Medicaid. And so that was no decision at all. Therefore, that's why the court said you were coercing the states because they have no ability to just simply withdraw under these circumstances. Therefore, their only choice, quote unquote, is to follow your dictate and expand Medicaid. That's the way the statute was written. Consequently, there's no choice. Therefore, it was coercion. That's unconstitutional. What should have happened is the entire Medicaid provision should have been struck down. But what in fact happened was Roberts rewrote the statute to say, well, we're going to give you a choice. If you don't want to give up your Medicaid and you don't want to expand it, you can opt out of this additional expansion. That's not permitted under the statute. It's just simply not there. He rewrote the section of the statute to something that just simply does not exist. It's unfortunate because I think what he ultimately did is he bowed to political pressure and he bowed to either the idea that he wants to have his own legacy and have his own independence. And frankly, I think this will be a nightmare that will follow him through the rest of his career because it ultimately undermines his credibility as a justice. And I think ultimately it will have many volumes of paper written about how uncritically analyzed this particular provision is by the Chief Justice.
Now, Liberty Counsel has weighed in on this issue of Obamacare. Matt, tell us about the lawsuit that you guys have filed, what it's about, and kind of where it's at in the pipeline.
Well, we filed the first private suit on the very first day the law was put into effect by President Obama on March the 10th, 2010. And in fact, on that particular day, we were the first of the private lawsuits, along with two other public lawsuits out of Florida and Virginia. We represent Liberty University and other individuals. That case was argued. I argued it before the district court, before the federal court of appeals, and it was the very first day of oral argument. That was the issue in our case that was argued, the Anti-Injunction Act at the U.S. Supreme Court. Our case is still pending at the U.S. Supreme Court. And we also had, in addition to the fact that Congress did not have the authority under the Commerce Clause and Taxing and Spending Clause, we also said an argument that it violates the free exercise of religion because it forces religious employers like Liberty University to fund abortion. That issue is still pending. We'll hear very soon from the U.S. Supreme Court whether they will send that back down to the Court of Appeals, at which case we'll start to re-argue that, and we'll already be at the Court of Appeals level, and then from there to the U.S. Supreme Court. If they don't, we'll just simply refile that in the district court. But we're not going away. This is a clear collision between the free exercise of religion and a government mandate. There is no compromise. This is not tangential to faith and the Christian viewpoints and practices of Liberty University or many other religious institutions. This is for the first time a direct clash, and it's unprecedented that we have this kind of collision course between the government and religious freedom.
With Hobby Lobby joined a lawsuit on this very issue. What a lot of people fail to appreciate, I think, about Obamacare is it didn't just apply to Catholic universities and Catholic hospitals. That was kind of the initial kind of focal point of the debate, but it applies to every Christian businessman. I mean, they have there's no respect in this law for the religious convictions of even a private business owner like Hobby Lobby. So the reach of this thing is just enormous.
Yeah, and you have to go back, like, for example, to Liberty University. It was January 23, 1973, the day after Roe versus Wade that was decided, that Dr. Falwell read in the Lynchburg News in advance the fact that the Supreme Court the day before had decided Roe versus Wade, the abortion case. And that was a defining moment in his life. That's ultimately what propelled him from preaching only behind the pulpit to impacting his community on these cultural issues, and why he was such a leader in these areas. And from that came the moral majority and other activism. Out of that came Liberty University. Of course, Liberty University was founded in 1971, but from the very beginning, the very core issue is that it is strong pro-life. This will diametrically collide with Liberty University's Christian core values. We're the largest Christian university in the world, and we simply will not be able to tolerate this. This is not something we can compromise or we can move around. This is a direct collision against our very existence and this federal mandate from HHS.
There's another issue on the cultural front of the homosexual agenda, and there's something a lot of our listeners are familiar with, but some may not be. Just an absolutely appalling piece of legislation that I believe has gone to the governor's desk. I don't know if he's signed it, but he will, that has to do with the homosexual agenda, and particularly teenagers that are trapped in this lifestyle. Tell us about that and what Liberty is prepared to do.
Yes, Liberty Counsel is representing a number of Christian counselors and other counselors in California and some organizations, as well as some parents and their minor children who are actually undergoing counseling right now. And this involves individuals who are minors who are having same-sex attractions. The House and the Senate both passed a bill. It's now on the governor's desk. He has not yet signed it, but he has until the end of September to do so, and it's likely that he will. This particular bill is just shocking, unprecedented. It will prohibit parents from taking their children, their minor children, to any counselor if that counselor seeks to counsel them regarding change. In other words, here's a young man, and he has a religious conviction that homosexuality is wrong, but he's having struggles with same-sex attractions. His mom wants to take him to a counselor to get assistance with that conflict. And he does not want to act out on, and has not yet acted out on, these same-sex attractions. And he's wanting to address these in counseling so he can resolve these issues and default on the side of his Christian viewpoint. If a counselor counsels, or if a parent takes this young man to a counselor, and that counselor counsels that individual about change or not acting out, if he does anything other than affirm that it is normal, natural, and healthy, this is a violation of the state law. It's absolutely incredible where it is intruding on parental rights. It's intruding in the doctor, the counselor-client relationship, and it is telling counselors that you can get one viewpoint of counseling. You can get affirmation for same-sex attractions, but you can't get anything that says that it's wrong or you shouldn't act out.
And what are you guys prepared to do?
We're preparing right now. We've been preparing for the last several weeks a federal lawsuit, and we will walk into court right after this is signed into law by the governor. I very clearly believe that this will be struck down as unconstitutional.
My guest has been Matt Staver. He is the founder and chairman of Liberty Counsel and the dean of the Liberty Law School. One of the great guys out there fighting the cultural war on the legal front. Matt, thank you so much for taking time to be with us, and God's best to you in everything you do at Liberty Counsel.
Thank you. My pleasure.
You're listening to Focal Point on AFR Talk. One segment to go. I'm going to have as my next guest in the next segment a reporter here from the UK with whom I've been conducting some interviews, but who was actually present when some of these Muslim protests erupted in the Middle East, and he'll tell us a little about his experiences when we come back. You're listening to Focal Point on AFR Talk. Don't go anywhere. We'll be back in just 2 brief minutes.